Driving While Intoxicated, DWI, New York VTL Section 1192.3 being charged with driving while intoxicated under New York Vehicle and Traffic Law Section 1192.3 can have serious consequences, even if your blood alcohol concentration isn't recorded. This law focuses on visible signs of impairment, making it critical to understand how these charges are handled and what your options are if you're accused. The legal landscape of VTL Section 1192.3 New York's DWI law under Section 1192.3 doesn't rely on a breathalyzer result. Instead, it centers on observable intoxication. Prosecutors must prove three core elements: that the accused operated or had control of a vehicle, that this occurred on a public roadway or area open to the public, and that the individual was impaired by alcohol to a degree that made safe driving impossible. Signs like slurred speech, unsteady movements, and the smell of alcohol can serve as evidence. Unlike per se DWI laws, where a BAC of 0.08% or higher automatically implies intoxication, this statute relies on subjective evidence. That makes it possible to challenge the basis of a charge, and a skilled attorney can help identify weaknesses in the prosecution's narrative. What to expect under New York VTL Section 1192.3 when you're charged under Section 1192.3, a conviction is not a given. There are multiple ways a law firm may contest the accusations. For example, challenging the legality of the traffic stop is one avenue. If the officer had no reasonable suspicion, any resulting evidence might be inadmissible. Another is questioning the officer's observations, especially if fatigue or medical conditions could have caused similar behavior. Procedural errors during arrest or testing could also work in your favor. The reality is, even without a recorded BAC, the consequences of a conviction can be steep. A lawyer will examine the facts from every angle to develop a defense that aligns with your unique situation. Understanding the DWI process in New York: to be convicted, the state must show beyond a reasonable doubt that you operated a vehicle while intoxicated by alcohol. Operation doesn't just mean driving, it can also mean sitting in the driver's seat with the engine running. The location matters too. It must happen on a road or area open to public use. The key issue is intoxication, whether alcohol impacted your physical or mental ability to drive reasonably. Take, for instance, someone who swerves between lanes, smells of alcohol, and performs poorly on field sobriety tests. Even if the breathalyzer doesn't work or isn't used, that person could still face charges under Section 1192.3. It's all about how the driver's behavior matches signs of intoxication recognized by law enforcement. The penalties are harsh. A first offense is a misdemeanor, with up to a year in jail, fines between $500 and $1,000, and license revocation for at least 6 months. There's often a requirement to install an ignition interlock device and complete alcohol screening or treatment. Repeat offenses within 10 years escalate dramatically. A second conviction becomes a Class E felony, and a third a Class D felony, each carrying higher fines, longer jail time, and extended license revocations. There are also long-term effects: a permanent criminal record, higher insurance premiums, mandatory court surcharges, and possible participation in victim impact panels or alcohol education programs. Unlike some other offenses, this conviction cannot be expunged in New York. It's vital to have an attorney who can guide you through the complexities of the law, safeguard your rights, and help mitigate the fallout from a charge under this statute. If you or someone you care about is facing a charge under New York VTL Section 1192.3, the Kugel Law Firm is here to help. We provide strategic legal defense tailored to your circumstances and fight for the best outcome possible. For support and legal guidance, contact the Kugel Law Firm at 212-372-7218 or visit us in person at 111 E 125th Street 2nd FL, New York, 10035, United States.